You're listening to IoT and IP Explained with Claudia Tapia, where experts discuss the latest in technology and intellectual property.
Welcome, everyone, to IoT and IP Explained. Today, I'd like to talk about licensing negotiations of patents essential to cellular standards like 4G and 5G. In particular, I'll focus on what courts expect from you, whether you are implementing these patents or you own them and have committed to making them available on fair, reasonable, and non-discriminatory terms, commonly referred to as FRAND terms. As you have learned in earlier episodes, cellular standards are one of the pillars of the Internet of Things. They offer wide coverage, high-speed connectivity, and low latency. Low latency means there's hardly any delay between sending and receiving data. The lower the latency, the better. Imagine two cars approaching each other. If the data is transmitted with a delay of a few seconds, one car might not react in time and a collision could occur. But if the delay is only a few milliseconds, that can be enough to avoid an accident and save lives. But to make critical communications possible or improve significantly existing communication, we need fast and reliable connections, as well as secure and resilient data transfer, even under failure, disruption, or attack. But if you're curious about how all this works, I recommend listening to one of our earlier episodes called Making Sense of Smart Technology, where I explain how devices communicate in the IoT and the different ways they connect. Let's continue with the cellular standards, because each generation, 3G, 4G, 5G, and soon 6G, requires around 10 years to develop and is the result of massive investment in research and development. In fact, some companies start R&D work years before the standardization begins. For example, Ericsson started industry discussions around 5G in 2011 and published its 5G vision in June 2013. However, 5G officially began years later in 2015. Naturally, many of these technologies contributed to its standard are protected by patents. When a patented invention is necessary to implement a technical standard, it's called Standard Essential Patent or SEP. To ensure that standards continue to evolve and achieve broad adoption, SEP owners typically license their patents on FRAND terms, either directly or indirectly by including have-made right clauses in the agreements. FRAND terms are determined in good faith negotiations between the patent owner and the company implementing the standard in its products or services. In the vast majority of cases, the parties reach an agreement. But if they can't agree on what's FRAND, the dispute may end up in court. Typically, the SEP owner requests an injunction while the user, also known as the implementer, raises a FRAND defense to stop the injunction from being granted. In Europe, the Court of Justice of the EU addressed this in its 2015 ruling in Huawei versus ZTE. The court set out mutual obligations for how the SEP owner and the SEP implementer should behave during licensing negotiations. Whether the court will grant or deny an injunction depends largely on whether they fulfill or not the respective obligation. By the way, you can find a summary of the ruling and how national courts have interpreted this case on the Council website. But for now, what is important for you to remember is that the courts assess the entire conduct of the parties, not just how one party responded to a specific action by the other. According to the Court of Justice of the EU, the SEP owner does not abuse a dominant market position when it notifies the implementer of the alleged infringement before filing a lawsuit and makes a FRAND offer, provided the implementer has expressed a willingness to take a license on FRAND terms. On the other side, if the implementer believes the offer is not FRAND, they must respond diligently and without delay, following recognized commercial practices and acting in good faith. This includes making a counteroffer and providing adequate security for potential royalties. In its ruling, the court left some questions for national courts to interpret according to the specific circumstances of each case. Let me give you some examples. What exactly must the notification include? Or what does without delay mean? And how do we know whether an offer is discriminatory? Let's look at how national courts and the Unified Patent Court have answered these questions. I'm going to start with national courts. What should you consider a SEP owner regarding the notification of the infringement? It's kind of like the first step, right? Here, the patent owner must notify the implementer before starting legal action, and the notification should specify the patent or patents, including patent numbers, the relevant standards, and also it has to indicate which products are allegedly infringing. The level of detail depends on the case and the experience of the implementer. The notification can also be directed to the parent company of a corporate group, and it's common practice to use claim charts for notification, and courts consider them sufficient to fulfill this requirement. So let's imagine we have already the notification of the infringement fulfilled. Now the next step will be looking at the implementer's willingness to conclude a license on FRAND terms. The implementer should seek a FRAND license as soon as possible. As a general rule, it is expected to express its willingness to obtain a license within 2 months of receipt of the infringement notification. The willingness must be clear, unambiguous, serious, and unconditional, and in a target-oriented manner to obtain a license on whatever terms are FRAND. German courts, in particular, pay close attention to whether a counteroffer was made and when. This encourages, in my view, timely and serious participation in negotiations. So if the notification has been made, the implementer has expressed its willingness to conclude a FRAND license, the next logical step would be for the patent owner to make a FRAND offer. But in order to reconsider FRAND offer, it has to include all essential terms of the agreement, explain the license conditions clearly and in such a way that allows the implementer to assess whether the terms are FRAND. So the SEP owner is initially only obliged to make an offer that is generally FRAND compliant with respect to the average licensee. Moreover, the SEP owner's duty to make a FRAND license offer is only triggered when the implementer has adequately expressed willingness to conclude a FRAND agreement. Also, offering a global license is consistent with industry practice in telecoms, lawful under competition rules, and compatible with Huawei versus ZTE framework. unless the specific case circumstances suggest otherwise, like when the implementer is only active in a single market. What is FRAND? Courts have made it very clear there is no single FRAND rate. Instead, FRAND is a range of acceptable terms. That means that one set of license terms can be FRAND depending on the situation. In any case, FRAND is flexible as it reflects what the parties agree in good faith negotiations based on their circumstances. Does it mean that the patent owner must treat every implementer exactly the same? No. Article 102 of the Treaty of the Functioning of the EU does not require what is called a most favored licensee clause. In other words, the SEP owner is not obliged to offer the exact same favorable conditions to all licensees, not even to similar situated implementers. Courts usually look at comparable agreements as evidence of FRAND compliance. Comparable agreements are real contracts concluded with third parties covering the SEPs in suit, or a patent portfolio including said SEPs. But not all agreements are valid comparables. For example, if a license was signed under financial distress or below market rates, it might not reflect the patent portfolio's real value. What about patent pools? Well, we have seen that courts have considered patent pool rates as having limited relevance when assessing FRAND. And that's because pools generally offer lower fees due to the volume of patents included. In licensing negotiations, while the FRAND offer is also typically based on comparable agreements, the SEP owner is not obliged to disclose the full content of all existing comparable agreements in order to protect legitimate confidentiality interests, if such exist. But let's imagine we have had the patent owner making the FRAND offer, but the implementer still doesn't think that that offer is FRAND. So here's where we will move to the implementer's FRAND counteroffer, because the counteroffer should in this case be made promptly and in line with recognized commercial practice. For example, if a company sells products globally but makes a counteroffer only for one country like Germany, that's inconsistent with how telecom licenses work. Just as the SEP owner is expected to present a specific and clear FRAND offer, the implementer should also make a specific counteroffer that includes comprehensive FRAND terms, not merely a proposed royalty rate. It's not enough to say the rate will be set by a third party, and unless the SEP's owner's offer is clearly not FRAND, the implementer must analyze it and propose any necessary changes through a counteroffer. Let's imagine now that the counteroffer has been made and that the SEP owner has rejected it. In this case, the implementer must render accounts about its use of the SEPs and provide security for potential royalties, both in accordance with its counteroffer. This must happen shortly after the first counteroffer is rejected, even if further negotiations follow. Delaying payment until a court or arbitrator sets the amount is not acceptable. Even if the implementer stops using the patents, its obligation to provide security and render account still applies. Let's now turn to the Unified Patent Court or UPC system. After its launch in June 2023, the UPC has delivered several rulings addressing FRAND-related issues. While its case law is still in its early stages, these initial decisions provide valuable insights into how the court intends to handle FRAND disputes. Generally, the UPC has made clear that the Huawei versus ZTE framework will continue to play a central role. In fact, the UPC has already referred to national decisions in its rulings, particularly those from German and Dutch courts. For instance, in relation to the notification of infringement, the UPC endorsed the view taken by German courts that the provision of claim charts is generally sufficient. The court also emphasized that the conduct of the parties during negotiations remains a decisive factor. In response to recent developments of UK case law that focus primarily on rate setting, the UPC stressed that FRAND cases are not solely about determining an appropriate rate. Rather, they also require an assessment of how the parties behave during negotiation. When it comes to the assessment of willingness, the UPC held that the implementer's overall behavior, including a potential counteroffer, should be taken into account. At the same time, the UPC noted that the SEP owner's initial offer must also be considered, introducing further nuance into the existing body of case law. The same applies with respect to the implementer's duty to provide adequate security. The UPC confirmed this requirement and added a further element. The implementer must also make a binding declaration that the SEP owner will receive the security amount as a royalty under certain conditions. In other words, this amount will be transferred to the patent owner as royalty income if the court finds that it behaved FRAND and the patent was infringed. Without such a declaration, the FRAND defense will generally fail. To conclude, the further development of the case law of the UPC is definitely something to closely watch, as the court is expected to become a key venue also for FRAND cases in the future. Wow, that was a lot of information, but in my view, it is key to understand how licensing negotiations work when it comes to a standard essential patent. I hope this episode gave you a clearer picture of that. FRAND is not just about numbers. It's about mutual responsibilities, fair process, and trust. Talking about trust, thank you so much for listening. If you found this episode useful, feel free to share it and check out earlier episodes for more context. Let's get in touch. Connected, we go further.